Hi, hello, welcome. Could you be so kind and share the presentation on my behalf?
I
Because I
will. I failed.
have
I failed a few
some
minutes
special
before. Maybe.
security settings that I'm not able to
Oh,
figure
okay.
out what I've done. So
Maybe I'm not gonna make the same IT mistakes, but let's
it's a pleasure to
see.
speak to so many people. Just before lunch is tricky, I know.
Just
Um,
let me know if it's okay.
yeah,
Can you see?
yeah. Thank
Great.
you.
Thanks.
So I am going to talk about, I would say 1.5 cases. Well, strictly speaking, it's two cases that concern the same matter um, that I filed on behalf of 12 children. On the picture, you see six of them, and that picture made it to the front paper on the Austrian tabloids. So whilst we, and I can say that already, failed in court, I do think we succeeded in the public debate. It was the first case that was entirely built on children's rights. And the idea was to make use of the constitutional rights that we have, that children have, the Federal Constitutional Act on the Rights of Children, and to take it seriously. Because if you do take it seriously, then it must mean something when you look at the climate crisis. I do think also when you look at the plastic crisis, but all these sort of other triple planetary crises, it becomes more complicated. But I do think there are constitutional rights after all. Maybe that was an accident. Maybe people in Austria didn't realize what power, in theory, constitutional rights should have. But this is where we're at. And maybe you can show the next slide because the starting point of this litigation, which was co-developed with 12 children, was really the fact that in Austria, we do have a very powerful Article 1 of the Federal Constitutional Act on the Rights of Children. That, if you look at the literature, it is sort of the common understanding that this grants subjective rights. So this is not just an aim that has to be pursued, but these are actual subjective rights of children. And that means that they do have a right to intergenerational justice or equity when it comes to the protection and care that is necessary for their well-being. What is quite interesting about this Article 1 that there isn't much jurisprudence on it, not even in sort of more children-related cases when it comes to family issues or asylum rights. It is brought forward, but the courts tend to sort of solve these matters more by Article 8 of the European Convention of Human Rights and sort of disregard that article. And I don't fully understand why, and maybe because children's rights somehow seem a bit alien. They are not. I mean, they are just like, at the end of the day, rights than any other rights, but somehow we treat them as if they don't really exist, if they're like a nice to have. And so the idea was to really at least communicate that in public that these rights exist and that they must mean something if they are constitutional rights and if they're drafted in the way that they are. Maybe from a practical point of view, how did this case come about? So these 12 children happen to be all children's of my friends and friends of my friends. So these are all parents that I knew and young people and children that I knew. It was important for me because I wanted to make sure that I can have thorough communication with them, that I understand what they want. They understand what my goal or aim is, that I do have, arguably have a strategic climate litigator. I do also have a goal in mind, and whether we have common ground here. Trust is very important. And I mean, again, it was the first cases where children went to court, publicly went to court. And so you really need a good relationship with the children and the parents. And any communication publicly, we said that the children have to be 14 years at least. So there were some younger kids, also one child with impairment that wasn't speaking in the public. So that was the first inspiration. The next slide. A second sort of side inspiration was also Article 24 of the Charter of Fundamental Rights, which arguably are fundamental and hence subjective rights. And they do play a role in the climate crisis because of the European Green Deal, the climate framework of the European Union, and therefore it also sort of plays a role. It was important also when it comes to the standing issue of the children, but I will sort of get to that point later. And then the third slide, our sort of legal basis for the lawsuit was the Federal Constitutional Act, the Charter of Fundamental Rights, and then the principle of equality before the law, which would mean and that we were sort of building on the decision of the German Constitutional Court, the principle of fair burden sharing, principle of objectivity. We're sort of drawing some narratives from there. And so the goal was to see, can you please share the next slide? What do these rights mean when it comes to the Austrian climate policy, and in particular to the Austrian Climate Protection Act? So in Austria, we have a very specific situation, maybe. We do have a Climate Protection Act that actually has no reduction targets anymore. So these targets that were very low to begin with, they ran out and they have never been renewed. Now, this act is already under challenge in a case before the European Court of Human Rights. It's the Müllner versus Austria case. Well, for those of you familiar with the jurisprudence of the European Court of Human Rights, our act does fail by even more standards than just not having any targets. We don't have a budget. We don't have any binding mechanisms. We don't have a complaint mechanism. And interestingly, basically, it's a very Austrian law, because in Austria, we like to solve issues by saying, well, let's just get together and have a cup of coffee and let's talk about it. And that's more or less what this law says. It leaves out the coffee, but basically it has, if you positively read into it, a duty to negotiate. Arguably, that's not even a duty, but not any duty to implement climate measures. Now, the big problem with the constitutional rights of the children, sort of the big piece missing, is any right to an effective remedy, any right to claim these rights. So the access to justice and the access to court has been left out. And now, so how do you bring these two things together? That was sort of the idea behind these two cases. Next slide. We do have a protection deficit in that realm where we arguably have, or the children have, rights for protection. We also say that because, or that was one line of arguing, that because these are sui generis rights, these are very specially created rights, there is even a stronger duty of the state to protect. The state actually embedded an active duty to protect. And obviously, now you can see that even from traditional sort of human rights, the European Convention of Human Rights, you already have a duty to protect in the face of the climate crisis. So even more so, you have that right. The state has that duty under the Federal Constitutional Act. But because we don't have any right to claim these, and we don't have an administrative or civil backup procedure in Austria, we have a very narrow, very closed system. The only sort of way of bringing these two things together, which is this very deficitarian Protection Act and these very strong rights, was to say, okay, well, let's challenge certain passages directly before the Constitutional Court of this act. And that is a very, very, very difficult task, because the idea is you do have a very badly drafted law. How can you, by repeal, that means crossing out passages, improve that law? And what is the role of the court in this? Because arguably the court cannot create laws. So it's a very, very thin line. It took us a very long time to find a way of creating or of ensuring that there is a duty to act. That if you cross passages and if you take all this constitutional framework you could end up with a better law, not an ideal law, but a better law that would actually improve the children's lives. We used a lot of argumentation or thinking that has been done by the Constitutional Court in Germany in the Neubauer case, because it does think about intergenerational burden sharing and equity. And that's very, very helpful to sort of find an Austrian way of this line of thinking. Now, I said it already, and it also holds true for general access to courts, and in particular the Constitutional Court in Austria. It's very narrow, it's very technical, it's very procedural. And under sort of a conservative understanding of the law, the children wouldn't have any standing, or it's difficult to argue that they have standing under the Climate Protection Act. What makes it now particularly challenging is the practical point of view, that you always have to think, okay, if the Constitutional Court stretches certain interpretations towards the children and loosen standing in regards to the Climate Protection Act, what does it mean for other norms, such as the pension system, budgets? Like how, stretching your standing and stretching the term intergenerational equity doesn't only have an impact on climate, but for follow-up cases, it does have impact on other sort of areas. So it could potentially open up a huge door that the court wouldn't want. So our idea was to frame this as a very, very specific case. The Climate Protection Act as a very unique challenge, because governing the climate crisis, and that is a very specific situation that's particularly impacting intergenerational equity and is particularly relevant for children. And so in this very specific case, the children should have standing directly based on their constitutional rights. And that is a thinking that hasn't happened before in Austria, that you base your right to challenge directly on the norm that sort of is infringed, and you don't make a link to the passage. That sounds very complicated and technical now, and I'm not sure if I do have time to go into details on how it works. But the idea was really to say, look, we do have these constitutional rights. Everyone says they're subjective rights. Everyone says they have a right to intergenerational equity. These rights must grant access to justice in this case, and a right to standing to challenge the one norm that is really very relevant for the climate crisis and for ensuring intergenerational equity and a right to care and protection that is adequate for children. We used Article 24 of the Charter of Fundamental Rights. I mentioned that before, because we were saying this is also applicable. And if you look at the Janicek jurisprudence, which concerns secondary European law in a completely different area, which is the right to clean air. Right to clean air, I'm just sort of using that as a phrase and not as a correct technical term here. Then, of course, if I have a right to challenge something based on secondary law, I must have a right to challenge something based on primary law. I must. So we're really trying to see whether we can bridge that protection deficit gap that arguably exists, and that's the reason why we don't have any jurisprudence on these very powerful rights. Next slide, please. And we approached the Constitutional Court 2 times, and we failed 2 times. And what's really sad is that we failed on entirely formal grounds with no thinking around the actual issues. I was really hoping to get a rejection that would sort of look into the actual problems we are facing as opposed to trying to avoid them. But this is the situation we face in Austria with the Constitutional Court on all matters relating to the climate crisis. It seems the court really does everything possible to avoid any substantive thinking arguments on these issues, let alone grant standing. And the request, which we sort of improved the second time round, so the first time the court rejected our repeal, saying you framed your requests too narrowly. What you want to be cut out of the law, this is just too narrow. This doesn't solve the problem. So we were like, okay, well, if that's your issue, if you're saying we haven't been fully bold here and we haven't sort of taken everything we can, we'll do it another time if that's the problem. So we refiled and made, as in the first petition, we had, I think, 3 requests. In the second one, we had 5 different ones. So we had loads of different requests on how this issue could be solved. Even saying, okay, if that's sort of too narrow, then let's kick out the whole act and at least make clear that children have a subjective right to intergenerational equity in very specific circumstances. Children can directly challenge a norm based on these rights with no other hurdles. Well, the second time, funny enough, it was too wide. So in some strange way, size matters, but nobody knows which one. So we tried it from XS to XXL and nothing works. And it really shows that, as I said before, the Austrian Constitutional Court just doesn't want to engage with the issue because it is clear. And it was so interesting that the first time I approached the Constitutional Court on a different repeal on behalf of an impacted person, an adult, all the commentaries by the judges were, well, this is not working, but the children, that must be a different story. So they were sort of hinting to the children. Because it's a sort of unique sector of society where you can maybe, treat it differently. And well, actually, you must treat it differently. And now the moment you approach the court with this, they were like backing off and not actually defending this decision in any way. There's not a lot of commentary. There's not a lot of discussion on what is actually at heart. And this is the end of these 2 cases, but not the end of my work regarding constitutional rights of children and the climate crisis. So what we've done is actually a year and a half, we started to demand or included children in an environmental impact assessment procedure that is still ongoing, where the plan is to construct a road over very fertile soil that is owned by farmers. And I'm not only defending the farmers, but the children of the farmers who want to take over the work from their parents. This case is ongoing. There is nothing substantial I can share at the moment. We're still sort of struggling with authorities on the first instance. But maybe the idea is if we can't go directly at what is at heart, namely the fact that we are breaching Paris Agreement blatantly, and we have constitutional rights of children, and we just don't bring those 2 together. If that doesn't work, which is very sad, maybe we have to go specifically through all different projects and things that sort of are the outcome of this reality, of the reality of the ignorance of the climate crisis. And maybe that's a way to tackle and bring in the constitutional rights that in Austria, are still in force. So I hope this has made sense to you. I know it's sometimes a bit difficult to share domestic cases in an international community because of very specificities that we have in our system. But generally, I do think we need to take children's rights the way they have been drafted more seriously and try and ensure that they really hold to what they promise in theory. Thank you.